Good afternoon, everybody. Welcome to WG University, Weber Gallagher's series of educational programs. This is our Commercial Transportation Group webinar series. I'm Jim Wesco, and I'm presenting today from our Philadelphia office. Today, we're presenting a current topic in commercial transportation legal issues. If you would like to view this webinar again, share it with others, or see our other WG University programs, please visit the Weber Gallagher website at www.wglaw.com, and you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is called The Act of God Defense in Cargo and Warehouse Claims and Litigation. And we're ready to get started. My name again is Jim Wesco. I'm the chair of the Commercial Transportation Department here at Weber Gallagher. And when asked to present today about a relevant topic in commercial transportation and cargo losses, my thought was with the proliferation of severe weather events that have been occurring these last few years, particularly in 2017, I thought it might be a good time to address the act of God defense in the defense of cargo claims and warehouse claims for motor carriers, rail carriers, warehousemen, marine operators, and the like. Anybody basically who's been hired to transport or store somebody else's property or goods, and what happens when they're destroyed or severely damaged in catastrophic weather or other meteorological events. So we'll get started right away. I just want to go over a brief summary of my presentation today. We're going to be talking about what the Act of God defense is, what it's not, what the basis of it is, statutory common law bases of it. Again, we're going to go through certain types, meteorological and weather events, geologic events, power outages, the actions of animals, sudden medical emergencies with drivers, other things like that. We're going to talk about the chances of success when trying to assert an act of God defense to a cargo loss or damage claim or a property loss or damage claim. What are the problems? What are the pitfalls? What do you have to overcome? And as we'll talk about, there are a lot of elements and facts that go into these types of decisions. And as we'll talk towards the end, you'll see that while on paper it may seem like a very logical type of defense that you're going to want to assert in these types of situations, it's not always as easy as it seems. So we'll talk about trends, strategies, and at the end I'll give you my thoughts and conclusions. Okay? Let's talk about it. First of all, what is the Act of God defense? And what we're talking about here is what we call an affirmative defense. What that means is it's something that the warehouseman or the motor carrier or the marine operator will assert when a claim is made against that party for cargo loss or property loss or damage. And basically what you're saying is, I'm not negligent, it wasn't my fault, it was an act of God. What it's not is a free pass. And we'll talk about that. There are lots of things that go into the act of God defense and a successful act of God defense. And they are a lot fewer and more far between than you'd think. Okay? Let's define an act of God. It's generally defined as a sudden, unexpected, and unavoidable manifestation of the force of nature. Right? It sounds pretty intense. There are bases for the Act of God defense. Federal and state law hold that a shipper cannot recover cargo damages against a carrier if an act of God caused the damage or loss or delay. The Act of God defense is available to carriers in many different modes of transportation. For ocean carriers, it's available through the Carriage of Goods by Sea Act, COGSA. It's available to air carriers, to motor truck carriers, and to rail carriers. For ocean carriers, like I said, it's COGSA, and it means that the carrier, or neither the carrier nor the ship shall be responsible for loss or damage arising or resulting from an act of God. The Harder Act, which is another maritime act, says the same thing. It gives you the existence of the act of God defense um, arising from what they call the perils of the sea. For air carriers, there's the Warsaw Convention and the Montreal Convention, which has a specific provision in there for acts of God. We're not going to really talk about that today. I just want to let you know that it is in existence. For motor carriers, motor truck and rail carriers, there is the Carmack Amendment at 49 U.S.C. 14706, which deals with loss or damage to goods in interstate transportation. And there's nothing specifically in the Carmack Amendment that says that an act of God exists. Right? It is a product of jurisprudential authority over the years as the courts have interpreted the Carmack Amendment. And what it means is, and it emanates back from the seminal case of Missouri Pacific Railroad versus Elmore and Stahl, which you'll see cited in all kinds of Carmack cases. But basically it means that there is an act of God defense for motor carriers, but it's conditioned upon the fact that the motor carrier itself has to be completely free of negligence. It's one of many such what we call affirmative Carmack defenses, such as the inherent vice of the product or something along those lines. The act of God defense is one of the most, the negligence of the shipper would be another excellent example of an affirmative defense, but an act of God defense is one of the most frequently cited or claimed types of affirmative defenses under Carmack. Let's just talk briefly about the history of the origins of the act of God defense. The specific origins really aren't known, but it goes all the way back to the English courts, all the way back into the 1500s and 1600s. And for 200 years, the rule was simply that an act could not happen by intervention of an act could not act as an intervention of man, or such as storms, lightning, or tempests. In other words, it did provide for an act of God defense under the old English law. The American courts adopted the English act of God defense, and the first reported case involving an act of God defense involved a steamboat sinking back in 1802. And as transportation law developed into the 20th century, now the 21st century, and as the climate's been becoming more and more prone to these catastrophic events, we've seen a fairly significant proliferation of act of God defense cases in the last 10 years. Let's talk now about what exactly is an act of God and when can it be successfully asserted. Okay? The most important thing that we need to know or to consider with respect to act of God defenses is that the event has to be catastrophic. It has to be significantly intense. It can't just be a bad storm. And as we'll talk about a little bit later, even a massive storm such as Sandy or Katrina, or going back into the 70s and the 60s, Hurricanes Camille or Hurricane Hazel, don't necessarily equate to an automatic successful assertion of the act of God defense. It helps. The bigger, the nastier, the more awful and catastrophic the event is, of course, the easier it is to assert the defense successfully, but that by itself does not automatically guarantee you success in that regard. There also has to be, there's an issue regarding the reasonable predictability of the natural occurrence. What does that mean? Well, it means, for example, in Hurricane Sandy or Superstorm Sandy, while it was incredibly catastrophic and caused billions and billions of dollars of damage along the eastern seaboard and far inland, as we may recall back in 2012, the storm itself was heavily tracked and followed, and there were probably a week to 10 days that went by as the storm slowly made its way up the eastern seaboard, which arguably provided notice to those storing or transporting other people's property. So it's hard to argue that a storm is unpredictable or unforeseeable if we have all this technology tracking it. So technology is making that type of the assertion of the act of God defense more difficult in that regard. I just talked about Sandy slow trek up the eastern seaboard. The argument there, if you're trying to defeat the act of God defense, is if your stuff is in somebody's warehouse and they don't take any steps to move it or elevate it or secure the warehouse or do something along those lines, and the warehouse is eradicated or destroyed or flooded as because of a catastrophic event, the fact that the storm was predictable and there was a fairly known track to it gives rise to the shipper's claim that you had a reasonable opportunity to do something but failed to do so, which, as we'll talk about, makes you sufficiently negligent to bar the application of the defense. There has to be a lack of human agency in the loss. What does that mean? It means the event can't be man-made, all right? It's truly an act or event beyond man's control. Now, we'll talk about what that means in a few minutes, but say a man-made event as opposed to a naturally occurring catastrophe could be something along the lines of a dam bursting or some type of a spillway overflowing, something that happened because of a pump malfunction or something along those lines that wasn't necessarily because of a catastrophic event, but because somebody somewhere forgot to do, or somebody designed something improperly, or somebody failed to monitor a dam or something along those lines. It's also another one of the facts associated with the act of God defense successfully is the reasonableness of the precautions taken by the defendant, by the warehouseman, or by the motor carrier. And what's reasonable under the circumstances? Every situation is different. Another key element in the analysis is prior occurrences. This is an interesting area of discussion because the act of God defense, in order to be successfully applied, means that something has to be inherently unpredictable. Now, there are two sides to that story. The first side of the story is that with the climate change scenario where storms are more frequent and less predictable and more severe than they've been in recorded history, that makes them more qualified as an act of God. But the fact that they are happening with more frequency and happening with more intensity, and even though there's a debate as to whether or not the cause of the climate change and the more severity and more frequency is man-made or not, the bottom line is it's known. We all know that these events are happening more frequently, and when they do happen, they're more severe. So that that in and of itself makes them more predictable and less subject to a successful act of God defense assertion. To be successful in an act of God defense, a carrier must show, quote, that the damage from the natural event could not have been prevented by the exercise of reasonable care by the carrier or bailee. And what we mean by bailee is a warehouseman or a marina operator who has barges or goods stored alongside the dock. And that's basically the rule. How have courts addressed the defense over the years? Let's talk about meteorological acts of God: hurricanes, tornadoes, blizzards, floods, lightning, and tsunamis. They are, like we said before, they are pure meteorological events. Man cannot create these occurrences, although many would argue that man's actions or inactions have made these occurrences more frequent or more severe when they do occur. But the bottom line is they are truly acts of God in that they are naturally occurring. Hurricanes, it's the most frequent source of the defense being applied. And again, as I said before, the bigger the storm, the better the chance that the act of God defense would apply. I'm just going to go back and give you some historical perspective on prior hurricanes as to when and where and whether the defense was successfully applied. Back in the late 60s, there was Hurricane Camille that devastated the Gulf Coast of Mississippi. There were successful applications of the storm The key to that was that Camille at the time was one of the most powerful, if not most powerful, hurricanes to ever strike the continental United States. And back then we had to remember that the technology available to the various weather agencies was nowhere near as significant as it is now. Hurricane Georges, I don't know if you remember that. That happened back in the late 1990s. The key issue there was some successful applications of the Act of God defense there for warehousemen. And the issue there was that the forecasters missed landfall by Hurricane Georges by about 150 miles. So the warehousemen that were along the path where the storm actually made landfall, some of them were actually able to successfully assert the defense because it truly was an unforeseeable event for them. They thought they were outside of the zone of danger, and they weren't. Hurricane Sandy is an excellent example of a storm that, just because of its sheer magnitude on its surface, would suggest that any claim made under Hurricane Sandy would have been applied successfully to the Act of God defense. There was one reported case out of the Southern District of New York, the Lord and Taylor case, which is frequently cited. And the court's finding in that regard was simply that Sandy was so intense, so large, so overwhelming that the warehousemen who owned all these warehouses right at sea level and whose seawall was higher than any recorded prior event or tide or flood ever, significantly higher, was still completely overrun and inundated by the sheer power and fury of Hurricane Sandy. So the court in that regard said, listen, sure, you may have had notice of Hurricane Sandy coming up the coast, and sure, we all knew it was powerful, but realistically and legally, nobody knew it was going to be this bad for this long and this powerful. So when the warehousemen claimed the defense, the court accepted the argument. The other side argued that, obviously, knowing that the storm was coming up the coast and knowing how severe it was, there could have been extra precautions taken. But at the end of the day, the court basically said, listen, nothing that man could have done could have prevented the type of destruction that Sandy caused. But on the other hand, we had a case down here in the Eastern District of Pennsylvania in Philadelphia by Judge Robreno, who found exactly the opposite. There was a warehouse filled with paper rolls that was inundated by Hurricane Sandy. And the judge said here in this case that the Act of God defense could not apply because there was something that the warehouseman could have done or should have done to have prevented the loss. He said basically that the evidence did not establish that the defendant could not have undertaken some task to prevent or at least mitigate the damage, particularly in light of the plaintiff's evidence the defendant had several days warning of the storm. Judge Robreno cited the plaintiff's contentions that the defendant could have taken several steps to mitigate its damages, including procuring flood insurance, which is a big deal for the court in that regard, moving the paper to racks off the floor, or for attorneys who defend warehousemen and trucking companies, the judge said in his opinion that perhaps the warehouseman could have taken the goods off-site. And as defense attorneys and as people who work for logistics companies and supply chain workers, we all know that it's physically impossible in the face of an impending storm, particularly something as catastrophic as Sandy, to get your stuff out of a warehouse. Sure, you might be able to elevate it, you might be able to buy some extra sandbags or procure some pumps, but in reality, you're not going to be moving anything out of your warehouse. And with respect to Sandy, how far could you have moved it to be out of danger? Sandy's wrath went as far inland as Illinois, it went as far north as Canada, and there was massive flood, rain, and wind damage to warehouses all the way that far inland. We're talking about thousands of miles. So how can you credibly argue that the warehouseman was negligent in failing to relocate the goods when in reality there was no safe place east of the Mississippi River to have moved the goods? Other rejection of the defense, we'll go back and look quickly at the Hurricane Opal. There was a rejection of an act of God defense. Reasonable preparations were available. Again, it all comes back to whether or not the warehouseman could have done something. With respect to floods, the floods arising back in the Nashville area back in the 2010-2012 time period, summary judgment was denied on an act of God defense based on the conclusion that the carrier could have taken measures to avoid damage caused by the floods in 2010. Again, it's a very fact-sensitive analysis, and there are many factors involved. The court looks at what was possible, what the climate usually is in these types of situations, what the frequency is for flooding with this particular body of water, things of that nature. In order for it to be an act of God, it's truly got to be sudden and completely unforeseeable. And again, with the way technology is nowadays, and with the way that everybody is aware that the frequency and severity of bad weather is on the rise, it's getting more and more difficult to truly throw your hands up in the air and say, we never saw this coming. Tornadoes are a little bit of a different story. Tornadoes are truly unpredictable, but again, if you're in Oklahoma or you're in Kansas and you're in Tornado Alley and you have a warehouse or you have a lot full of trucks where you store stuff in the trucks, it's arguable that you would have noticed that these types of things could happen during particular times of year, and your decision to keep stuff in those locations might be enough to hang the 1% of negligence on you to prevent application of the act of God defense. Non-named storms, the analysis is even more fact-intensive. Depends on the duration of the storm. It also depends on what type of ship or what type of facility we're talking about. If we're talking about ocean cargo types of losses, what's the size of the ship? What are the wave intervals? All types of meteorological, factual considerations go into this. And there's clearly no mechanical test. As we'll see, if you look at the cases, I don't want to go through all the cases, but to look at these cases, you'll see that the courts really go into great detail about the history of the location, the expectations of the parties, what's happened in prior situations. It's all about what the warehouseman or motor carrier should have reasonably expected to have occurred, and having known that, what actions they took in the face of the impending storm, if in fact the storm was something that could have been predicted in the first place. Now, if you're talking about a tornado, of course, or a meteor dropping out of the sky, those are completely different things, or a tsunami or an earthquake, those are different things. But a named storm, a hurricane, or something like that, that's different. What about rain? We're talking about this in the context of some prior cases, but now with Hurricane Harvey in South Texas, this is certainly going to be a relevant line of cases. This one case, this Nortec case, involved a 15% chance of forecast of rain in Houston, and 13 inches of rain fell in one day. And the court in that case said that truly was unforeseeable. It truly was an act of God, and there was nothing that the warehouseman could have done to have prevented the loss, and the act of God defense was successfully asserted. There are all types of cases about that. There's other cases where there's, during monsoon season, for example, when the massive amounts of rainfall are expected, you can't apply the defense. Freezing temperatures in an area where freezing temperatures occur isn't an act of God. Snow and blizzards, avalanches. Avalanches can arguably be an act of God. They're rare cases, but snow causing massive delays can be an act of God. But again, maybe not necessarily if you're transporting goods across the Dakotas or Montana or Wyoming in January or February. You're probably not going to be able to successfully argue the defense. But perhaps a freak snowstorm in Alabama in December, possibly. And and there are lots and lots of cases out there. If you're involved in one of these situations, you could probably find a case to support your argument, but at the same time, you're probably going to find a few cases that go the other way. So again, this is a very fact-intensive analysis. Some of the cases you have to look at when you're looking at this and you're trying to find a case to support you, you really have to be careful as to when the ruling was issued, because a lot of these older cases were issued when forecasts were not nearly as reliable. So you have to take that into consideration when you're looking at whether or not you're going to try to assert the defense. With respect to wildfires, it depends on who started the fire, really. Was the fire controllable? Again, what's the human cause of it? What's the human interaction? Is it truly an act of God? Volcanoes, yeah. There are other cases involving the eradication or decimation of a species because of some natural event, and those are different. Those aren't really cargo cases, but I threw that in there just to give you an example as to how fact-intensive these types of situations are. A bridge collapsed because of an earthquake? Maybe, maybe not. It depends on the facts. It depends how the case is worked up. And there was a case on the materials involving that. What about earthquakes that cause damaged road beds to rail transit? That's a possibility. Flash floods with respect to motor carriers? That's a possibility. Down in Oklahoma and in the southern part of the United States, we have new issues now where there are earthquakes allegedly caused by fracking, which is the shale gas extraction process. Are those man-made events, or are they naturally occurring events? That's an interesting, if there's property damage caused to goods in storage because of an earthquake triggered by fracking, that's not necessarily an act of God. It's a man-made event that resembles an act of God. What about coastal flooding from global warming? Is this man-made? That's an argument to be made that it's not an act of God. I'm going to talk briefly about acts of animals, whether or not an animal coming in front of a tractor trailer is potentially an act of God. Really, it depends on the animal. Right? If it's a truly wild animal, it could arguably be an act of God. But if it's a cow that gets away from its pasture, that's a domesticated animal, and it got out because of some screw up by the rancher, then it's not an act of God. It's the failure of man to contain a domesticated animal. I want to talk briefly about sudden medical emergencies with drivers. With all the old drivers now, with all their attendant medical issues, sleep apnea, high blood pressure, diabetes, is a driver passing out for an unforeseeable medical emergency an act of God? Well, again, that goes to notice. What does the motor carrier know or should reasonably expect to know about the medical condition of its driver? Those are, in negligence cases, there's a clear split among the courts, but not in the cargo context. And no, with respect to maritime claims, a captain blacking out is not an act of God, like in a storm. Again, the key is foreseeability, and all these cases are going to be different. Power failures. If a power failure comes and knocks out power to a warehouse and there's spoilage or damage or some type of a critical system is disabled that causes the cargo to be damaged or destroyed, is that an act of God? The courts have generally said no, even if a hurricane causes power outages, because the argument there that's been successfully made is that there was some intervening act of man or some failure of man to make the system more foolproof or to prevent those types of accidents happening in the first place. Same thing if a power grid is struck by lightning. The courts have said that lightning strikes are an expected type of and foreseeable type of natural occurrence that the power company should have reasonably foreseen and taken steps to prevent. So losses arising from a lightning strike to a power grid, for example, are not acts of God. Strategies for analyzing whether or not to assert the defense. Again, it is a very fact-intensive analysis. And you should be aware now, as we were after Sandy, with the claimants that are going to be coming out after Irma and Harvey and all the other hurricanes that happened in the last year and even the last few years. particularly in household goods storage cases, where there's going to be arguments that there should have been something that the warehouseman did, or there should have been something to do that he did or that he failed to do that could have prevented or mitigated the damage. These are very expensive cases to defend. They're very expensive cases to try. You often get into a situation where you've got meteorological experts, you've got logistics experts who will argue on both competing sides that there was nothing that could have been done, or there was everything that could have been done, or that the storm was or wasn't as severe as the other side is contending, or that it was or wasn't as predictable as the other side is contending. It just becomes very difficult. And if you're defending one of these cases, if you're defending the warehouseman or you're defending the motor carrier, chances are you're going to be trying that case or litigating that case in a jurisdiction where people on the jury are going to be similarly situated with respect to having suffered a loss from that particular natural occurrence, and it's going to be very hard to find sympathy to you as a warehouseman who may have insurance and who's still denying the claim. So there are a lot of considerations to be factored into, because the people who are going to be on the jury for one of your cases might have been the same person who's been denied coverage by their insurance company for damage to their house from the same storm, and they might not be in any mood to listen to your arguments about how you're not responsible for damage to somebody else's stuff through the same event. Remember, an act of God is by definition a rare event, and events once perceived as acts of God are now perceived to be acts of man. That doesn't mean you should be discouraged. You shouldn't treat the defense as an ancient relic. Weather forecasts are improving. They're providing notice to carriers and warehousemen. So you need to know that it is still available, but the key is, like I said before, while man is getting better at predicting nature, it gives us the ability to avoid loss or damage from these storms, but at the same time the storms are becoming more and more powerful, which makes doing anything possible in the first place. And again, I said before, watch out for old cases when you're looking up your strategies to make sure that you're not looking at something where the technology was bad and the predictability was an issue. Remember, when you're asserting the act of God defense, it's a two-pronged test. First of all, there has to be, of course, as we said, the act of God. It can't be applied to a gust of wind or heavy rain. It has to be an epic event. Right? An epic event. That's probably the best way to describe it. The second prong of the defense, which is really the most difficult prong, is the fact that the shipper or the motor carrier or the person applying the defense must be free from negligence. Right? 1% negligence defeats the application of the act of God defense. You've got to be completely free of negligence. You have to be able to convince the court or the jury that there was nothing you could have done, and everything that you did do was completely reasonable. And that is a very difficult bar to overcome. It's a very difficult bar to overcome. Could you have put on some more sandbags? Could you have rented a few more pumps? Could you have moved some trailers on your lot to a higher elevation? Could you have gone out and procured additional flood insurance in the days leading up to the event? There are lots of things that you maybe could have done, which arguably could be construed to be sufficiently 1% negligent to bar you from using the act of God defense successfully. All right. Let's talk about trends. Again, as I said, the frequency and severity of these massive catastrophic events is increasing. Along with that, as I'm sure we'll see in the next few years, hundreds, if not thousands, of lawsuits and claims arising from the hurricanes of 2017, particularly in South Texas and Western Florida, against warehousemen, household goods warehousemen, moving and storage companies, motor carriers, for storage and transit and permanent storage. and the defendants are going to be trying to assert the act of God defense. So we're going to see, I think, lots more cases on this in the next few years, which is always a good thing from an attorney's perspective, because the more case law out there with decisions makes it easier for the attorney to counsel their client appropriately on how to proceed in a particular claim. What you need to do, as I said before, is be careful when and where you make your argument. You have to look at whether or not the carrier or warehouseman took reasonable precautions, and can you demonstrate that they're free from negligence? Again, sandbags, elevations, did they evacuate? Did they relocate? Did they reposition? Did they buy more insurance? What about the decision in the first place to lease or buy or own a warehouse that you know is in a flood zone? Is that in itself sufficiently negligent? 1%. Let's say you rent or lease a warehouse that is in a flood zone, and you buy flood insurance, and the place is never flooded in 500 years, but then a storm like Sandy comes along and it floods. There's an argument that can be made. I don't think it's credible, but it is an argument to be made, and it can stick, is that your decision to put a warehouse where you're going to be storing other people's treasured and valued possessions in an area that is vulnerable is sufficiently negligent to bar application of the act of God defense. It's that fact intensive. Okay? Thank you very much. Those are my comments about the act of God defense. I appreciate your time. Thank you for attending the webinar. You can learn more about this program and all of the Weber Gallagher events at www.wglaw.com/wg-university. Thank you very much.